When you file a court case, a suit or any other case, you may file against a couple of respondents or defendants. For example, A sold property to B, B sold property to C, C sold property to D, and you purchased from D. Now you have a dispute with D. You must not only make D as a party, you must make A, B, C, D as parties. Now A, B, C will be proper parties in the court and D will be necessary party. Because D violated your right, D must compulsorily be made a party and is called a necessary party, against whom court will grant relief to you. The rule of evidence is that whosoever files a case must enter the witness box. Whosoever replies to the claim of the plaintiff or the petitioner must enter the witness box and suffer cross-examination. Today I am going to share with you the exception when you file a reply to the claim of the plaintiff, but you don't need to enter the witness box. Under what circumstances you don't need to enter the witness box? Here, in the instant case on hand, A, B, C are the proper parties and D is the necessary party. D alone knows the facts of the dispute with you. A, B, C doesn't know the facts of the issue or the facts of the dispute. D is having the direct knowledge of the facts of the dispute. So D must enter the witness box and A, B, C need not enter the witness box but must give reply. That is important. Reply must be given. If reply is given and the party doesn't enter the witness box, an adverse inference is taken by the court. But if reply is given and party doesn't enter the witness box because it doesn't know the facts of the case, court will not take adverse inference. So this is the exception where you have to file a reply claiming that you are not interested in the dispute or you are not connected with the dispute or you are connected with the dispute indirectly. But you need not enter witness box. Court will not take adverse inference if you file a reply and you do not enter the witness box when you doesn't know the facts. Because what happens in cross-examination? The facts that are not brought to the court or the facts that are suppressed by the party to the case are dug or brought out by the other party or the opposite party in the cross-examination. That is the purpose of cross-examination. Otherwise, what is the purpose of the cross-examination? It will be the first half of the story and the second half of the story will be the cross-examination. The first half will be the examination, the second half will be the cross-examination. Generally in court, any party will inform his version of the dispute to the court. The opposite party will inform the other version, the hidden version, the gaps, the suppression. So the main characters of the case are the necessary parties and the supporting characters of the case are the proper parties and the supporting characters need not enter the witness box. The main character must enter the witness box, must suffer the cross-examination, must give the reply. So this is the exception for a person who files a reply and doesn't or need not enter the witness box. This was the principle that was created by Honorable Supreme Court in Kaur case. Hope I am clear. Thank you. Thanks for watching. If you have any doubts, kindly comment.